The surveillance footage from the Elgin County Courthouse hallway captured it perfectly. A 14-year-old boy in a pressed white dress shirt, hands tucked lazily into his pants pockets, smiling at his own reflection in the darkened glass of a courtroom door. It was September 2019. His father had been dead for 11 days. The boy's name was Dylan Mercer. And in that courthouse hallway, surrounded by grieving relatives and stone-faced detectives, Dylan Mercer looked like a kid who had just won something. He had told investigators he was devastated. He had told his school counselor he couldn't sleep. He had told the family pastor he prayed every night for answers. But the camera doesn't lie, and what the camera recorded in that hallway was not grief. It was satisfaction. It was the quiet, private satisfaction of someone who believed, with absolute certainty, that he had gotten away with it. The smirk lasted 4 seconds. Those 4 seconds would be played, frame by frame, in front of a jury 12 months later. Dylan Mercer was 14 years old. His father, Robert Mercer, was 41. Robert had been a high school physics teacher in Westfield, Ohio, the kind of man who stayed after class to help struggling students, who coached the junior varsity track team without extra pay, who made pancakes shaped like geometric equations on Sunday mornings just to make his son laugh. Robert Mercer was, by every account of everyone who knew him, a genuinely good man. He died on the morning of August 29, 2019, after ingesting a concentration of thallium sulfate so precise, so deliberate, and so methodically administered over 6 weeks that the Westfield County Medical Examiner would later call it, the most calculated poisoning I have encountered in 22 years of forensic work. And then there was Dylan, the boy who bought the poison, researched the dosage, documented the results, and smiled at his own reflection in a courthouse hallway while investigators processed the crime scene inside his family home. Dylan Mercer acted, from the very first moment, as though none of it would ever stick to him. He was 14. He was charming. He was articulate and composed in a way that made adults instinctively lower their guard. He had answers for everything. Smooth, practiced, unhurried answers. The kind that come not from innocence but from preparation. This is the story of what happens when arrogance collides with forensic science. When a child who believes himself smarter than every adult in the room discovers, too late, that the room has been watching him the entire time. Dylan Mercer poisoned his father across 43 days, documented his progress in a private journal he encrypted on his laptop, and stood in a courthouse hallway and smiled. He was 14 years old when he committed the crime. He was 15 when he was tried as an adult. He was 16 when Judge Patricia Harmon looked down at him from the bench and sentenced him to 85 years in a state correctional facility. Stories like this remind us that justice, no matter how long it takes, always finds its way. If you believe in accountability, subscribe now and share your thoughts below. Because this story is only beginning, and what the evidence reveals about Dylan Mercer is something none of his teachers, his coaches, or even his own family ever saw coming. The smirk in the hallway. That is where this story begins. Not in the courtroom. Not in the lab where forensic chemists identified thallium in Robert Mercer's hair, fingernails, and blood. But in a hallway in September 2019, where a 14-year-old boy looked at his own reflection and smiled. Because in that moment, Dylan Mercer believed he was untouchable. This story is about the moment he found out he was wrong. By the time Judge Harmon delivered her sentence, the courtroom had gone so quiet that spectators would later describe hearing the air conditioning hum. Dylan Mercer heard 85 years and did not cry. He did not flinch. He simply looked down at the defense table, jaw tight, fingers flat against the surface. The smirk was gone. And it would never come back. Westfield, Ohio sits in the crease between two low hills about 40 miles east of Columbus, the kind of town where the diner on Main Street still has a chalkboard specials menu and where the high school football team's playoff wins are painted on the water tower. Population 8,200. One stoplight. A volunteer fire department. A public library that closes at 6 p.m. and is still the most visited building in town. Westfield is not the kind of place where things like this happen. Which is, of course, exactly what people said afterward. Robert Mercer had lived in Westfield his entire life except for 4 years at Ohio State, where he studied physics education and met his wife, Karen, at a library study group during midterms. They married in 2003. Dylan was born in 2004. Karen Mercer left the marriage in 2011, when Dylan was 7, citing irreconcilable differences, a term that, in their case, concealed something quieter and sadder. Two people who loved each other but had grown into incompatible versions of themselves. The divorce was civil. The custody arrangement was 50-50. Robert Mercer never said a word against Karen in front of Dylan, a fact that Karen herself would later tearfully confirm at trial. Robert taught AP Physics and Introductory Chemistry at Westfield High School. His students described him as one of those rare teachers who made difficult concepts feel personally important, who could take the law of conservation of energy and make a room of teenagers feel as though understanding it mattered to their actual lives. He was known for patience, for consistency, for never raising his voice. Former students who are now adults drove back to Westfield specifically to testify at trial about what kind of man Robert Mercer was. He coached junior varsity track from 2014 until his death. He organized a weekly chess club for middle schoolers that met in his classroom on Thursday afternoons. He donated blood every 8 weeks. He checked out library books and always returned them on time. These details are not offered to sanctify Robert Mercer or to make him larger than he was. They are offered because they are true, and because they are the opposite of what Dylan Mercer's defense attorneys would later try to construct. A complicated, flawed, absent father who had somehow provoked his son's rage. The provocation narrative collapsed under cross-examination. Neighbors testified that Robert spent every available weekend with Dylan. His sister described Robert as the most present single father I've ever seen. Dylan's own friends, when interviewed by investigators, said they wished their dad was as cool as Dylan's. None of this fit the defense's portrait. None of it explained what came next. But it illuminated, with devastating clarity, the depth of Robert Mercer's innocence and what was done to him. In the summer of 2019, Robert Mercer had just begun to feel, by his own account in text to his sister, that things were looking up. He had applied for a department chair position. He was planning a road trip with Dylan to visit Ohio State, where Dylan had expressed interest in studying engineering. He had started running again, logging miles on the trail that looped behind the elementary school. He was, by every measurable indicator, a man moving forward. He had no idea, in the summer of 2019, that his own son had begun researching poisons. Thallium sulfate is not a substance that appears in casual internet searches. It is an industrial compound historically used as a rat poison, now largely banned from commercial sale in the United States. Accessing it requires either a chemical supplier account, a research institution connection, or a carefully anonymized online purchase routed through the dark web. Dylan Mercer, at 13 years old, had opened a Tor browser, found a supplier operating through an encrypted marketplace, and placed an order using a prepaid Visa card purchased with cash from a CVS 3 towns over. He had done this 7 months before his father's death. He had been planning for 7 months. Robert Mercer ate the pancakes Dylan made him on the Sunday before he died. Dylan had added the final dose to the maple syrup. Robert said they were the best he'd ever had. He told Dylan that over text, a text retrieved from his phone by investigators. "Best pancakes ever, buddy. Thanks for making them." Dylan read the message, set his phone face down on the kitchen counter, and went upstairs to his room. What he did up there, alone, in the hour after his father sent that text, that is a question that would haunt every person who heard it read aloud in court. Robert Mercer was found unresponsive on the kitchen floor at 7:14 a.m. on August 29, 2019. The 911 call was placed by Dylan. The recording is 22 seconds long. Dylan's voice is calm, not the manufactured calm of someone fighting hysteria, but the flat, measured calm of someone who had already processed what was happening. Dispatch asked if the person was breathing. Dylan said he wasn't sure. Dispatch asked if he had tried to wake him. Dylan said yes. Dispatch asked his name and age. Dylan gave them correctly. The operator who took the call later told investigators she remembered thinking in the moment that the boy sounded like he was placing a pizza order. First responders arrived at 4 Birchwood Lane at 7:21 a.m. Robert Mercer was on the kitchen floor near the refrigerator, non-responsive, with no visible trauma. Paramedics noted his pulse was weak and irregular. His skin had an unusual pallor. His hair, and this detail would become critical, was thinning in a way that seemed inconsistent with his age. Paramedics initially suspected cardiac arrest. He was transported to Westfield Memorial Hospital, where he was pronounced dead at 8:03 a.m. The attending physician, Dr. Carolyn Walsh, noted the pallor, the hair loss, and an unusual peripheral neuropathy pattern she had seen only once before in a textbook. She flagged the case for the medical examiner. Dr. Marcus Ibarra, Westfield County's chief medical examiner, received the referral at 11 a.m. He had been a forensic pathologist for 22 years. He later testified that within the first 30 minutes of examination, he was working from a hypothesis that he had never encountered in an actual case, only in the academic literature. The symptoms were consistent, precisely and comprehensively, with thallium poisoning, The alopecia, the peripheral neuropathy, the Mies lines visible on the fingernails, the gastrointestinal damage that had been misread as a stress response. I ordered the toxicology panel immediately, Dr. Ibarra testified. I already knew what I was looking for. The toxicology results confirmed thallium sulfate at a concentration that, while not instantly lethal, had been accumulating in Robert Mercer's body over a period estimated at 4 to 7 weeks. The forensic chemistry report noted something extraordinary. The dosing pattern was not random. The concentrations found in Robert's hair, which grows approximately 1 centimeter per month and retains chemical exposure like a timeline, showed a clear escalation curve. Whoever administered the poison had started with small amounts and increased the dose incrementally over time. This was not impulsive. This was monitored. This was adjusted. Detectives from the Westfield Police Department arrived at 4 Birchwood Lane with a search warrant at 2 p.m. on August 29. Dylan Mercer was seated at the kitchen table with his aunt, Carol Mercer, who had come to be with him while his mother drove from Cincinnati. Detective Sergeant Anita Flores noted that Dylan was not crying. He was eating a granola bar. When she introduced herself, he looked up, extended his hand for a handshake and said, "I figured you'd come." Flores later described that exchange in her incident report and circled the word, "figured." It was not a word a bereaved 14-year-old reaching for comfort tends to use. The search of the house took 6 hours. In Robert Mercer's bathroom, a prescription bottle of antacids with traces of an unidentified white powder in the cap lining. In the kitchen pantry, a bottle of maple syrup with a small puncture hole near the base of the cap seal, consistent with syringe injection. In Dylan's bedroom, a laptop, password protected, with browser history partially wiped. In Dylan's desk drawer, a CVS receipt for a prepaid Visa card dated January 14, 2019, 7 months before Robert's death. And in the false bottom of a shoebox beneath Dylan's bed, a handwritten list in pencil of dates and corresponding observations. The first entry, Day 1 minimal effect. Increasing dosage next week. The last entry, dated August 26, Day 43, should be enough now. Sergeant Flores photographed the list without disturbing it. She placed it in an evidence bag. She walked out of Dylan's room and down the hallway, where Dylan was now sitting with his aunt watching television. She stood in the doorway for a moment. Dylan glanced at the evidence bag, then back at the TV. He did not ask what was in it. He did not ask anything at all. Flores later testified that in her 18 years of law enforcement, across hundreds of death investigations, she had never had a suspect fail to ask what was in an evidence bag removed from their room. "The innocent ones always ask," she said. Dylan didn't ask because he already knew. The case was referred to the county prosecutor's office that evening. By midnight, detectives had identified the encrypted dark web marketplace, traced the prepaid Visa purchase, and begun the process of petitioning for Dylan's laptop to be forensically examined by the state crime lab. Robert Mercer had been dead for 16 hours. His son had already stopped pretending to grieve. The Ohio Bureau of Criminal Investigation's Digital Forensics Division received Dylan Mercer's laptop on September 1, 2019. Senior forensic examiner Dale Rutherford had worked data recovery for 11 years. He had cracked encryption on laptops belonging to cartel operatives, domestic terrorists, and organized crime figures. He later told prosecutors that Dylan Mercer's encryption setup was, pound for pound, more sophisticated than most of what he saw from adult criminal defendants. "This wasn't a kid who stumbled into a security tutorial," Rutherford testified. "This was a kid who understood exactly what he was trying to hide and exactly how to hide it." It took Rutherford's team 9 days to penetrate the encryption. What they found inside was a meticulous, disturbing record of premeditation that would ultimately become the spine of the prosecution's case. Dylan's browser history, recovered from deleted files through data carving techniques, revealed a research timeline stretching back to December 2018, 8 months before his father's death. The searches began with general terms: undetectable poisons, poisons that mimic natural illness, how long does it take to die from poisoning? They became progressively more specific: thallium sulfate symptoms, thallium half-life in human tissue, hair analysis, thallium forensics. Does thallium show up in standard tox panel? That last search, conducted on January 3, 2019, was among the most damning pieces of evidence in the entire case. Dylan had specifically researched whether standard hospital toxicology panels would catch thallium. They typically don't, because thallium poisoning is rare enough that most labs don't include it in routine screenings. Dylan had known this. He had researched it. He had planned around it. The fact that Dr. Ibarra flagged the case based on clinical observation rather than waiting for a standard panel was the precise contingency Dylan had not accounted for, and the single deviation from his plan that unraveled everything. The journal was the centerpiece. Stored in an encrypted folder labeled Physics Notes, it ran to 47 entries spanning 43 days. Written in a calm, analytical style that forensic psychologist Dr. Renee Hartley later described as clinical dissociation, the journal documented Robert Mercer's deterioration with the detachment of a scientist recording an experiment. Entry 8. Hair loss beginning on crown. Consistent with timeline in reference paper. Entry 17. Complained of leg tingling at dinner. Told him it was probably stress. He agreed. Entry 29. Much weaker today. Skipped coaching practice. This is on schedule. Entry 43. Should be enough now. There was no expression of doubt. There was no expression of regret. There was, at one point in entry 22, a single sentence that would be quoted in virtually every piece of coverage the trial received. He trusts me completely. That makes this easier. The dark web purchase trail led investigators to a British Virgin Islands-based chemical supplier operating under rotating pseudonyms. With the assistance of federal law enforcement, prosecutors were able to subpoena transaction records showing a purchase of thallium sulfate in a quantity of 5 grams. Enough to kill an adult male of Robert Mercer's body weight several times over, routed through a Monero cryptocurrency transaction on January 19, 2019. The delivery address was a UPS store 2 towns from Westfield, registered to a fake name. Dylan had walked into that UPS store on February 3 and picked up the package without incident. Investigators interviewed Dylan's classmates, searching for behavioral changes, confidence, or any indication that he had told someone what he was planning. Nothing. Dylan was universally described as sociable, well-liked, and kind of private. His teachers described his academic performance as exceptional, specifically in chemistry where he was enrolled in an advanced elective. His chemistry teacher, Miss Patricia Cole, recalled that Dylan had asked her, in November 2018, about the real-world applications of heavy metal compounds in biological systems. She had thought nothing of it at the time. He was a curious kid, she said. I thought it was wonderful. The investigation expanded to include phone records, which revealed something particularly striking. During the entire 43-day poisoning period, Dylan's text communications with his father were warm, frequent, and affectionate. He sent his father memes. He shared track results. He initiated plans for the Ohio State road trip. On August 18, 11 days before Robert's death, as the journal recorded significant deterioration, Dylan texted his father, "Gonna make you pancakes Sunday. Don't make plans." Robert responded with 3 heart emojis and "best son ever." Dylan read it and did not respond for 40 minutes. When he did, he sent a smiley face. Every text, every search, every journal entry, every transaction. The evidence assembled into a portrait that was, in the words of prosecutor Diane Kovacs, not the product of a troubled child acting in a moment of crisis. It was the product of a cold, methodical, calculating mind that had been planning a murder for the better part of a year. The only question that remained, the one that would define the legal argument for the next 12 months, was whether that mind at 14 years old was capable of being held fully accountable. The answer, ultimately, would come from Judge Patricia Harmon. But it would take a long time to get there. The court-ordered psychological evaluation of Dylan Mercer was conducted over 4 sessions in October and November 2019 by Dr. Samuel Greer, a forensic psychologist with 25 years of experience evaluating juvenile defendants in capital and near-capital cases. Dr. Greer had evaluated 340 juvenile defendants in his career. He later testified that Dylan Mercer was, in his professional judgment, among the most psychologically complex juvenile subjects I have ever encountered, and among the most troubling. Dylan was cooperative throughout the evaluation. Cooperative in a way that Dr. Greer described as performative compliance. A pattern he associated with certain personality profiles in which the subject understands that appearing cooperative serves their interests. Dylan answered every question. He maintained steady eye contact. He responded with apparent thoughtfulness to emotionally weighted questions. He expressed sadness about his father's death in words that were clinically appropriate. The problem, Dr. Greer noted in his report, was that the emotional content and the physiological indicators never aligned. His voice described grief. His body showed none of it. The evaluation identified a constellation of traits that Dr. Greer classified, with appropriate clinical caution, as consistent with emerging narcissistic personality features combined with what he described as highly developed suppression of empathic response. Dylan demonstrated a markedly elevated need for control, a persistent belief in his own exceptionalism, and an almost total inability to conceive of his father as a fully realized person whose experience mattered independently of Dylan's own. When asked to describe his father's life, Dylan described his father's relationship to Dylan. When asked what he missed most about his father, Dylan said after a long pause, "The routine." The motive question, the one the public most wanted answered, proved the most elusive. There was no single dramatic precipitating event. Robert Mercer had not abused his son. He had not neglected him. He had not remarried, announced a move, altered Dylan's financial expectations, or done anything that rose to the level of a trigger. The prosecution's theory, supported by Dr. Greer's evaluation and developed through additional testimony from a second expert, Dr. Vivian Torres, was that Dylan had killed his father as an exercise in control. The motive was not anger, Dr. Torres testified. The motive was the act itself. The planning. The execution. The certainty that he could do this and not be caught. For this type of profile, the crime is the motive. Dylan's school records contributed a supporting layer of context. He had received disciplinary action in 7th grade for submitting a lab report that was later discovered to have been fabricated, not copied from another student, but invented. He had fabricated data that closely mimicked what actual experimental results should look like, suggesting not carelessness but deliberate deception. When confronted, he had denied it calmly and consistently until the evidence was placed in front of him, at which point he accepted responsibility with no apparent distress. His guidance counselor noted in his file, "Dylan does not appear to experience accountability as meaningful." She had written that in March 2018, 16 months before Robert's death. Dylan told Dr. Greer in their third session that he had always known he was different from other people, that he found it easy to understand what others wanted to hear and to provide it, that he found other people's emotions confusing in the sense that they seemed disproportionate to the situations that caused them. He spoke about his father's death using passive constructions, when the situation changed, after everything happened, almost never placing himself as an agent in the events. Dr. Greer noted this in his report with the observation that the avoidance of agentive language was consistent across all 4 sessions and appeared to be habituated rather than strategic, meaning Dylan had, at some level, already rewritten his own role in his mind. There is a moment in Dr. Greer's notes from the final session that received particular attention when excerpts were shared with the press during the trial. Dylan had asked, with what Dr. Greer described as apparent genuine curiosity, how long people typically served under an 85-year sentence. Dr. Greer had not at that point given Dylan any indication of what sentence he might face. The evaluation occurred months before trial. When Dr. Greer asked why Dylan had mentioned that specific number, Dylan said, "I read about a case like mine." He then smiled and changed the subject. Dr. Greer wrote in his notes, "Subject appears to have already calculated the range of likely outcomes and has adjusted his expectations accordingly. The absence of fear is not performed. It is genuine." The prosecution would use Dr. Greer's evaluation to argue that Dylan Mercer was not a confused child acting in crisis, but a calculating individual who understood exactly what he had done, had planned it across months, and would pose a continuing danger if not removed from society for a significant period. The defense would use it to argue that Dylan's psychological profile was itself evidence of a developmental disorder that reduced his culpability. What no one disputed, not the prosecution, not the defense, not any of the mental health professionals, was that Dylan Mercer was, by any reasonable measure, unlike any other 14-year-old defendant any of them had ever encountered. The decision to try Dylan Mercer as an adult was not made automatically, and it was not made quickly. Ohio law permits the transfer of juvenile defendants to adult court in cases involving serious felonies when certain criteria are met, including the nature and circumstances of the offense, the defendant's history, and the likelihood that rehabilitative services available in the juvenile system would be adequate. Prosecutor Diane Kovacs filed for adult transfer certification in November 2019. The certification hearing began in January 2020 and lasted 3 days. Judge Patricia Harmon, who would ultimately preside over the adult trial, was at this point serving as the presiding judge of Westfield County's Juvenile Division. She had been on the bench for 17 years, 8 of them in juvenile court. She was known in legal circles for measured, careful rulings, the kind of judge who read every exhibit, interrogated every assumption, and wrote opinions that were cited by other courts. She was not known for drama. She was known for precision. At the certification hearing, Dylan Mercer walked into the courtroom in a navy blazer and khakis and took his seat beside his public defender, attorney Marcus Webb, with the posture of someone settling in for a meeting they were not particularly worried about. Courtroom observers noted that he spent the first 15 minutes of the hearing sketching something in a notebook. When a court officer asked him to put it away, he complied without looking up, capping his pen slowly, deliberately, in a way that somehow communicated boredom rather than compliance. The prosecution presented a condensed version of the evidence: the journal, the toxicology, the digital forensics, sufficient to establish probable cause and the gravity of the alleged offense. Webb argued that the juvenile system was designed precisely for cases involving young defendants whose moral development was incomplete, and that the state's own psychological evaluation acknowledged developmental factors that should weigh against adult transfer. He asked the court to consider that Dylan had no prior criminal record and had demonstrated academic excellence. Markers, Webb argued, of a young person who could respond to rehabilitation. Dr. Greer testified at the certification hearing, and it was here that his evaluation of Dylan received its first public airing. He stated his conclusion carefully, that while Dylan's developmental status was a genuine clinical consideration, the planning involved in the offense, spanning 8 or more months, involving international procurement of a controlled substance, sustained deception of the victim and deliberate dosage management, went beyond what the juvenile system's rehabilitative framework was designed to address. "We are not talking about an impulsive act," Dr. Greer said. "We are talking about a sustained campaign. The distinction matters enormously when we think about what response is appropriate." Dylan watched Dr. Greer testify with an expression that attorney Webb would later describe as analytically interested. He took notes. At one point he passed a note to Webb that read, according to Webb's later account, "He's wrong about the developmental piece. Ask him about the Roper Standard." Webb did not ask about the Roper Standard. He did not think it was the moment for a 14-year-old to be coaching his defense attorney's cross-examination strategy. The note itself became, informally, one of the most discussed elements of the hearing among the attorneys present. It demonstrated, in a single gesture, exactly the cognitive capacity that the prosecution argued made adult transfer appropriate. Judge Harmon issued her transfer ruling on February 14, 2020. It was 11 pages long. She found that the nature of the offense, its duration, its sophistication, its premeditation, and the defendant's demonstrated awareness of and attempts to circumvent forensic detection, weighed decisively in favor of adult transfer. She noted Dylan's psychological evaluation with care, acknowledging the clinical picture it presented, but concluded that the juvenile system's maximum jurisdiction of 5 years was wholly inadequate to address the severity of what occurred. She certified the case for adult prosecution. Dylan Mercer heard the ruling read aloud. He sat very still. He nodded once, slowly, as though confirming something he had already calculated. He turned to Webb and said something quietly. Webb later confirmed what it was. "What's our first motion?" Not, "What does this mean?" Not, "What happens now?" The first question Dylan asked upon learning he would stand trial as an adult for first-degree murder was about litigation strategy. He was 15 years old. The trial was set for September 2020. Dylan went back to the juvenile detention facility, asked for access to the law library, and began reading case transcripts. Prosecutor Diane Kovacs had been with the Westfield County District Attorney's Office for 14 years. She had prosecuted homicides before. She had not prosecuted anything like this. She spent the 7 months between the certification ruling and trial preparing a case that she knew would face 2 major challenges: the defendant's age, which would generate sympathy regardless of the evidence, and the complexity of the forensic science, which had to be made comprehensible to 12 jurors who were not chemists. She described her trial preparation strategy in a later interview as building a bridge between the lab and the living room. The forensic case rested on 5 pillars. First, the toxicology report confirming thallium sulfate poisoning and the dosing timeline reconstructed from Robert's hair sample analysis. Second, the digital forensics, the browser history, the encrypted journal, the dark web transaction. Third, the physical evidence from the search, the maple syrup bottle with the injection hole, the antacid container with residue, the handwritten observation log. Fourth, the financial trail, the CVS receipt, the prepaid Visa transaction record, the cryptocurrency exchange log, the UPS store security footage showing Dylan picking up the package. Fifth, the behavioral evidence, the 911 call recording, the hallway surveillance footage, the testimony of Sergeant Flores and the courthouse dispatch operator. Each pillar was reinforced by expert testimony. Dr. Ibarra would testify about cause of death and the clinical presentation of thallium poisoning. Dr. Rutherford would testify about the digital forensics. FBI Special Agent Taryn Nguyen would testify about the dark web transaction trace. Dr. Greer would testify about the psychological evaluation. Dr. Ingrid Holm, a forensic hair analyst from the Ohio State University Crime Lab, would testify about the timeline of poisoning reconstructed from Robert's hair samples, arguably the most visually powerful element of the prosecution's case, because it allowed the jury to see, in a chart, exactly how Robert's exposure escalated week by week. The defense strategy, as Attorney Webb developed it, rested on three arguments. First, that the psychological evidence established a developmental disorder. Specifically, that Dylan's profile was consistent with autism spectrum disorder presenting atypically, which Webb argued explained the behavioral anomalies without implying predatory intent. This argument had not been raised during the psychological evaluation and would face significant challenge from Dr. Greer's rebuttal. Second, that the physical evidence had chain-of-custody vulnerabilities, specifically, that the maple syrup bottle and the antacid container had been handled before proper documentation. Third, that the journal, while damning, was the product of a disturbed adolescent fantasy life rather than an actual record of events. The third argument was the most aggressive and, as it turned out, the most consequential to demolish. Webb was arguing essentially that the journal was fiction, a disturbed creative exercise that happened to coincide by tragic chance with Robert Mercer's death from the same poison Dylan had researched. This argument required the jury to disbelieve the physical evidence, the digital evidence, the financial trail, and the behavioral record simultaneously. Kovacs later described her reaction to learning this was the defense's position as, "The moment I knew exactly how to build my closing argument." Jury selection ran for 2 days in early September 2020. The defense sought jurors who were parents of teenagers, hoping for empathy toward a minor defendant. The prosecution sought jurors who could process complex forensic evidence without being swayed by emotion. The final jury consisted of 7 women and 5 men ranging in age from 28 to 61. Among them, a retired pharmacist, a high school librarian, a chemical engineer, 2 nurses, and a retired Army logistics officer. It was not, several legal observers noted, a jury that would be easily misled about how poisons worked or what meticulous documentation looked like. Dylan arrived for the first day of trial in a suit that was slightly too large for him, a detail his attorneys had likely chosen deliberately, to emphasize his youth and smallness against the gravity of the proceedings. He sat with his hands folded on the defense table. When the jury filed in, he looked at each of them in turn with what several jurors later described, in post-trial interviews, as evaluative, as though he were assessing them rather than being assessed. Juror number 4, the retired pharmacist, later said, "I remember thinking, this kid is looking at us like we're the ones on trial. It gave me a chill I didn't shake for the whole trial." Opening statements began on September 14, 2020. Kovacs stood before the jury and said, "Ladies and gentlemen, you are going to hear a great deal in this trial about Dylan Mercer's age. You are going to hear about what the brain of a 14-year-old is and is not capable of. I want to tell you right now what the evidence will show. A 14-year-old brain planned this murder for 8 months, researched it across 37 documented internet sessions, procured the poison through an international dark web purchase, administered it across 43 days, documented its effects in a private journal, and stood in a courthouse hallway 3 days after his father's death and smiled. The age of the brain matters. The actions of that brain matter more." The trial's first week was devoted to the forensic foundation. Dr. Ibarra testified for a full day about cause of death, the clinical presentation of thallium poisoning, and the method by which he identified the toxin despite it not appearing in a standard panel. He was methodical and unemotional in a way that made his testimony more powerful, not less. Each fact delivered with the precision of a man who had examined thousands of bodies and had no need to dramatize the one in front of him. He described Robert Mercer's final weeks as a medically coherent deterioration consistent with chronic, incrementally increasing thallium exposure. He showed the jury the Mies lines on Robert's fingernails in an enlarged photograph. The lines were white, horizontal, precise. The jury looked at them and several members looked away. Dr. Holmes' testimony about the hair analysis was the forensic showpiece of the first week. Using a laser ablation technique that analyzes chemical concentrations along individual hair strands at intervals corresponding to growth rate, she had produced a timeline of Robert Mercer's thallium exposure accurate to within a few days. She presented this as a color gradient chart projected on a screen visible to both the jury and the gallery, A visual record of a man being slowly poisoned, beginning in mid-July and accelerating through August. The chart showed the exposure levels rising in a curve that was not random, it was deliberate. It rose in steps. Someone had been controlling it. Sergeant Flores testified about the search of 4 Birchwood Lane and the discovery of the physical evidence. She described the shoebox under Dylan's bed, the false compartment, the handwritten observation log. The log was entered into evidence. Excerpts were read aloud by Kovacs, slowly, each entry dated. The courtroom was very quiet while they were read. When Kovacs read entry 22, "He trusts me completely. That makes this easier." Karen Mercer, seated in the gallery, pressed her hand over her mouth and looked at the ceiling. Dylan sat at the defense table and looked at his hands. The digital forensics consumed much of the second and third days. Dr. Rutherford walked the jury through the process of recovering deleted files, explaining data carving and encryption in terms that were accessible without being condescending. He displayed the browser history timeline on the court's projection system, a scrolling list of searches, dates, and timestamps that began in December 2018 and extended through August 2019. As it scrolled, the pattern was unmistakable: a systematic, progressive education in how to poison someone and avoid detection. When the search, "Does thallium show up in standard tox panel?" appeared on screen, a juror, later identified as juror number 9, one of the nurses, audibly exhaled. FBI agent Nguyen testified about the dark web transaction, walking the jury through the cryptocurrency trail and the UPS store security footage. The footage was played twice. It showed Dylan, in a baseball cap, alone, carrying a backpack, entering the UPS store, presenting a pickup slip to the counter clerk, accepting a package roughly the size of a shoebox, and leaving. He was 13 years old in that footage. He walked out of the store with his hands in his pockets. He did not look around. He did not appear nervous. He had planned for this too. Webb's cross-examinations during the first week were competent but constrained. He challenged chain of custody for the maple syrup bottle, suggesting it had been handled without gloves before evidence bags were applied. Flores acknowledged a brief period between collection and bagging during which the bottle sat on the kitchen counter in a paper evidence bag without a secondary seal. The concession was minor. The injection hole and the residue inside the cap were consistent across multiple analyses, but Webb pressed it as evidence of investigative sloppiness. The jury, containing a chemical engineer and 2 nurses who understood contamination protocols, appeared unimpressed. On the 4th day of testimony, the journal was formally entered into evidence as Exhibit 34. Kovacs read selected entries to the jury in full. She read them in the order they were written, and she read them slowly. She did not editorialize. She did not pause for effect. She simply read Dylan Mercer's words in the quiet of a courtroom where 43 days of a man's death were laid out entry by entry, with the calm documentary detail of a scientist recording results. By the time she finished reading entry 43, 3 jurors were crying. Dylan Mercer was not. The first week ended with the prosecution on strong footing and the defense's journal as fantasy argument visibly weakened. Webb had not yet called his witnesses, but the structural problem with his theory was already apparent. Each new exhibit tightened the evidentiary mesh another notch. The journal alone could, in theory, be explained away. The journal plus the purchase records, plus the syrup bottle, plus the hair timeline, plus the surveillance footage, there was no single innocence narrative that threaded through all of it simultaneously. Kovacs had built exactly the bridge she intended. The jury could see it. Dylan, watching from the defense table, could see it too. Attorney Marcus Webb called his first witness on September 21. Dr. Olivia Marsh, a child neurologist and developmental specialist from Cincinnati who had evaluated Dylan in August 2020, a year after the crime. Dr. Marsh testified that Dylan exhibited features consistent with high-functioning autism spectrum disorder. Specifically, difficulties with emotional reciprocity, advanced pattern thinking capacity, reduced social emotional integration, and what she described as a dissociative relationship with the emotional consequences of action. She argued that these features, combined with Dylan's age, meant he could not fully appreciate the moral weight of what he had done in the way a neurotypical adult would. The testimony was carefully constructed and clinically articulate. Dr. Marsh was an experienced witness. She spoke clearly, cited peer-reviewed literature, and described Dylan with evident professional care. The problem, which Kovacs began dismantling on cross-examination within 20 minutes, was that the ASD diagnosis had not existed before the trial preparation phase. Dr. Greer's evaluation, conducted in 2019, had not identified ASD. Dylan's school records contain no prior evaluations, no IEP, no teacher-flagged concerns about autism spectrum presentation. The diagnosis appeared to have been generated specifically for trial. Kovacs was surgical and cross. She asked Dr. Marsh whether she was aware that the DSM-5 criteria for ASD included difficulty with deception and manipulation as characteristics inconsistent with the diagnosis. Marsh acknowledged there was clinical debate on the point. Kovacs asked whether an individual presenting with ASD would typically demonstrate the sustained, sophisticated deceptive behavior documented across Dylan's 43-day poisoning period. The warm text to his father, the concerned son performance for teachers and neighbors, the deliberate concealment of evidence. Marsh began to answer and Kovacs interrupted. Does the clinical literature support autism spectrum disorder as a framework for understanding 8 months of premeditated deception? Marsh said the literature was nuanced. Kovacs moved on. Webb's second witness was Dr. Jerome Falk, a juvenile justice reform advocate and criminologist who testified about brain development science, specifically the Supreme Court's holdings in Roper v. Simmons and subsequent decisions establishing that adolescent brain development is meaningfully different from adult cognition. Falk was an effective witness on his area of expertise. His testimony was compelling, well-sourced, and humanizing. He described the prefrontal cortex's development timeline, the adolescent limbic system's disproportionate influence on decision-making, and the research consensus that adolescents are more impulsive, less future-oriented, and less capable of fully understanding consequences than adults. Kovacs's cross-examination of Falk was the defining moment of the defense case. She asked him, Dr. Falk, in your review of the research on adolescent brain development and impulsivity, does the literature account for planning periods of 8 months? Falk said the literature addressed varying planning durations. Kovacs asked, does the adolescent impulsivity research apply to a defendant who, over 8 months, researched his poison, procured it internationally, planned delivery mechanisms, monitored its effects and adjusted dosages, maintained parallel deception of the victim, researched forensic detection methods to anticipate investigation, and documented everything in an encrypted private journal? Falk said the developmental framework was relevant regardless of planning duration. Kovacs turned to the jury and said, no further questions. Dylan did not testify. Webb had considered it. There was a school of thought that Dylan's articulateness and apparent composure might humanize him for the jury, but the risk of Kovacs cross-examining him against the journal entries was considered too significant. The jury would not hear Dylan's voice explaining himself. What they had heard instead was his voice in the journal. The entries read into the record were, in effect, Dylan's testimony. And they had already spoken. The defense rested on September 25th. Closing arguments were scheduled for September 28th. In the 5 days between, the legal community following the case debated the outcome. The consensus was that the prosecution's case was overwhelming as a matter of evidence. The question was whether the jury's knowledge of Dylan's age would override the evidence in the way it sometimes did in cases involving minor defendants, whether the visceral human reluctance to condemn a child to a life in prison would produce a lesser verdict despite the weight of proof. Kovacs prepared her closing argument with this dynamic in mind. She needed to redirect that reluctance, not dismiss it. On the evening before closing arguments, the courthouse security footage from the hallway, the 4 seconds of Dylan's smirk, was played at a preliminary hearing regarding a related evidentiary matter. Several courtroom observers saw it for the first time. One of them, a reporter for the Columbus Dispatch, later wrote, I have covered courts for 15 years. I have seen defendants be cruel, be remorseless, be defiant. I have never seen anyone look the way Dylan Mercer looks in that footage. He doesn't look guilty. He doesn't look relieved. He looks proud. And that is somehow worse than anything else. Prosecutor Diane Kovacs began her closing argument on September 28, 2020, at 9:07 a.m. She stood at the podium without notes for the first 3 minutes. She looked at the jury and she spoke about Robert Mercer. Not about the evidence. Not about thallium. Not about encrypted journals or dark web purchases. About Robert Mercer, the man who made pancakes shaped like equations, who stayed after school for students who didn't understand, who coached track without extra pay, who sent his son 3 heart emojis and said, best son ever, 11 days before that son delivered the final lethal dose. Robert Mercer did not know he was being killed, Kovacs said. He died believing he was sick. He died believing his son was grieving. He died in a house where the person he trusted most had been methodically taking his life for 6 weeks. He died not knowing. That is the most important thing I will say today, and I want you to hold it. Robert Mercer died not knowing. She paused for 5 seconds. The courtroom was absolutely still. Then she moved to the evidence. The closing argument lasted 3 hours and 40 minutes. It was structured in 3 acts. The first act reconstructed the timeline of the crime from Dylan's first internet search in December 2018 through his father's death on August 29, 2019. 8 months collapsed into a relentless chronological sequence that left no gap for coincidence. Every exhibit was referenced. Every date was anchored. The jurors had seen each piece of evidence in isolation over 2 weeks of testimony. Kovacs assembled it in front of them like a completed puzzle, each piece locked into place with a click of specificity. The second act addressed the defense's arguments directly. The autism argument. Kovacs acknowledged Dr. Marsh's testimony and then dismantled it with precision, noting the late-stage genesis of the diagnosis and the fundamental incompatibility of an ASD framework with the sustained, adaptive, deception-dependent execution of the crime. The diagnosis appeared, Kovacs said, when it was needed. The evidence exists from before the defense needed it. Trust the evidence. The Fantasy Journal argument. She read entry 22 again. He trusts me completely. That makes this easier. And asked the jury to consider whether a fantasy document would have been stored in a false bottom shoebox under the author's bed, separated from discovery by concealment rather than by fiction. The third act addressed age directly. You have heard, Kovacs said, that adolescent brains are different. That is true. You have heard that teenagers are more impulsive than adults. That is true. What you have also seen is the evidence. And the evidence does not describe impulsivity. The evidence describes the opposite of impulsivity. It describes patience, planning, adjustment, monitoring, concealment. Over 8 months. These are not the products of a brain that acted without thinking. These are the products of a brain that did nothing but think, that calculated every element of this crime and executed it with a precision that adults with fully developed prefrontal cortices rarely achieve. She stopped. Then, the question before you is not whether Dylan Mercer is young. He is young. The question is whether what he did was a crime. It was. She returned to Robert Mercer in her final minutes. She described the Sunday morning pancakes. She read the text, "Best pancakes ever, buddy. Thanks for making them." She let it sit in the room. Then she said, Robert Mercer trusted his son with his breakfast, with his home, with his life. That trust was the weapon Dylan used against him. Ladies and gentlemen, it is time for the truth to matter. It is time for Robert Mercer to matter. I ask you to return a verdict of guilty on all counts. She sat down. The courtroom was quiet for a moment, not the restless quiet of a room waiting for something to happen, but the settled quiet of a room where something had just been completed. Judge Harmon called a 30-minute recess. In the hallway, Karen Mercer sat on a bench with her sister and did not speak. Dylan Mercer was returned to the holding area. Attorney Webb, preparing his own closing, reviewed his notes and did not speak either. Several jurors later described Kovacs's closing as the definitive moment of the trial, not because it revealed new information, but because it arranged what they already knew into a shape they could no longer look away from. Juror number 4, the pharmacist, said, after she finished, I knew how I was voting. I think everyone knew. The deliberation wasn't about what to decide. It was about whether we were sure. And we were. The jury returned to its hotel that night. They would hear Webb's closing the next morning. Then they would deliberate. Then they would decide. Attorney Marcus Webb delivered his closing argument on September 29th. It was disciplined, compassionate, and ultimately inadequate to the task. He spoke for 2 hours. He returned repeatedly to Dylan's age, to the science of adolescent brain development, to the court's own recognition in Roper v. Simmons that youth is constitutionally relevant to culpability. He argued that the ASD diagnosis, while challenged, introduced reasonable doubt about Dylan's full moral capacity. He described Dylan as a child who needed help that no one recognized he needed, in ways that no one had the tools to provide. He made one moment work. He showed the jury a photograph of Dylan at age 9, a school photo, grinning, gap-toothed, holding a soccer ball. He placed it next to the prosecution's evidence chart and said, "This is the same person. You are being asked to sentence this person to spend the rest of his life in a state prison. Before you do that, I am asking you to be certain. Not confident. Certain." It was effective as a moment of humanity. It did not shift the evidentiary weight. But it would trouble at least 2 jurors through the deliberations that followed. The jury began deliberating at 2:14 p.m. on September 29th. They deliberated for 11 hours and 43 minutes across 2 days. The extended deliberation, longer than many observers expected given the strength of the prosecution's case, reflected the genuine moral difficulty of the decision. Not uncertainty about what Dylan had done, but anguish about what to do with him. Post-verdict interviews confirmed this. "We knew he was guilty from the first hour," juror number 7 said. "The question was whether we could live with what guilty meant for a 16-year-old. That took longer." The deliberations were not contentious in the usual sense. There were no holdout jurors arguing for acquittal. The debate was about the specific counts, whether the evidence supported first-degree murder with premeditation as charged, or whether a lesser homicide conviction was more appropriate given the defendant's age. The chemical engineer, juror number 11, reportedly anchored the conversation about the dosing timeline. If the jury accepted the hair analysis, the deliberateness of the dose escalation was incontrovertible. The librarian, juror number 3, reportedly returned repeatedly to entry 22 of the journal. "He trusts me completely. That makes this easier." She said she read it 12 times during deliberations. On October 1, 2020 at 10:47 a.m., the jury notified the court that it had reached a verdict. The courtroom filled within 20 minutes. Karen Mercer was in the front row of the gallery with her sister and a victim advocacy coordinator. Robert's sister Carol sat 2 seats away. Attorney Webb sat beside Dylan, who had arrived from the holding area in his oversized suit and was seated with his hands flat on the table. He did not appear agitated. He appeared attentive, a student waiting for test results he believed he had already calculated. The jury filed in. The four-person juror number 1, a 54-year-old retired Army officer named Gerald Price, stood with the verdict form. Judge Harmon asked if the jury had reached a verdict. Price said yes. Harmon asked him to publish the verdict. Price read, "On the charge of murder in the first degree, we the jury find the defendant, Dylan Mercer, guilty." He read the remaining counts: conspiracy to commit murder, criminal procurement of a controlled substance, and the verdict on each was guilty. Karen Mercer closed her eyes when the first guilty verdict was read. Carol Mercer gripped the railing in front of her. In the gallery, the courtroom was completely still. At the defense table, Dylan Mercer sat and listened to each verdict read without moving. His jaw tightened slightly on the first count. On the subsequent counts, nothing registered. When Price finished, Dylan turned to Webb and said something. Webb nodded. What he said was never publicly confirmed, but Webb, in a later interview, acknowledged that Dylan's first question after the guilty verdicts was about the sentencing guidelines. Judge Harmon polled the jury individually as required. Each juror, called by number, confirmed their verdict. When it came to juror number 4, the pharmacist, he looked at Dylan directly as he said, "Guilty." Dylan looked back at him. The eye contact lasted 2 seconds. Then Harmon thanked the jury, released them, and set the sentencing hearing for November 15, 2020. Dylan was remanded to custody. He walked out of the courtroom between 2 officers, and the doors swung closed behind him. Robert Mercer's family sat in the gallery for a long moment, not speaking. Justice at last had a shape. The sentencing would give it a number. The sentencing hearing on November 15, 2020, began with victim impact statements. Ohio law entitles the victim's survivors to address the court before sentencing, and 3 people had submitted statements: Carol Mercer, Robert's sister; Karen Mercer, Robert's ex-wife and Dylan's mother; and James Whitfield, one of Robert's former students, now 23, who had driven 4 hours from his graduate school program in Pennsylvania to speak on Robert's behalf. Each of them stood at the podium in the quiet of the courtroom and said what a life had meant, and what its ending had cost. Carol Mercer spoke first. She was 53, a nurse, with the composed bearing of someone who had spent decades managing her emotions in clinical settings and who was now discovering, in real time, the limit of that composure. She described Robert as a boy, a younger brother who collected baseball cards and memorized batting averages and once tried to explain the infield fly rule to their mother for 45 minutes without success. She described him as a father who had called her every Sunday for 9 years without exception, to tell her what Dylan had done that week. He was so proud, she said. Every week there was something new. Something Dylan had learned or tried or built or said. He never ran out of things to tell me. He never sounded anything but proud. Carol's voice broke once, on the word Sunday, and then she steadied herself. She looked at Dylan, who was seated at the defense table with his hands in his lap. Dylan met her gaze. Carol said, "I don't understand what happened to you. I don't think I ever will. Robert loved you more than anything in his life. I watched him love you. And somehow, that wasn't enough. I don't know what to do with that. I don't know how to understand it. But I want you to know that I remember who he was. I will remember who he was for as long as I live. And no sentence, no courtroom, no verdict changes that. He was my brother. He is my brother. Nothing you did changes that. Karen Mercer stepped to the podium after Carol. She had not spoken publicly throughout the trial. She had been present every day, seated in the gallery, contained, watchful, but she had not given interviews and had declined all comment requests from reporters. At the podium, she unfolded a single sheet of paper, looked at it, then folded it and set it aside. She spoke without it. She spoke about Robert and Dylan together, about the years after the divorce when Robert had remained, in her words, the most generous co-parent I can imagine. About how Robert had never weaponized Dylan against her, never diminished her role, never placed his own grievances ahead of their son's stability. Then Karen turned to Dylan. Her voice was very quiet. She said, I have sat in this room for 6 weeks and listened to what you did. I have listened to the journal. I have listened to the searches and the orders and the doses. I have listened to all of it. And the thing I keep coming back to is not the evidence. It is the Sunday you made him pancakes. The Sunday you sat across from your father at breakfast and you watched him eat something you had poisoned, and he said they were the best he'd ever had, and you let him believe it. You let him believe he was loved. She stopped. Looked down. That is the thing I will never forgive. Not what you did to him. What you let him believe while you did it. Dylan watched his mother deliver her statement without expression. Those watching for a response, any response, saw nothing. No flinching. No tears. Nothing that looked like the impact of those words landing somewhere vulnerable. One journalist in the gallery wrote in her notes, he listens to his mother describe his father's death and he looks like someone reading a report about something that happened to other people. I have never seen grief so completely absent from a room that should contain nothing but grief. James Whitfield spoke last. He was brief and direct. He had been a student in Robert's AP Physics class in 2017, struggling and on the verge of giving up the course. Robert had stayed with him 3 afternoons a week for 6 weeks until he understood momentum and could solve the problems on his own. Whitfield passed the AP exam. He was now in a graduate physics program. He said, I don't know if Mr. Mercer knew what those 3 afternoons meant to me. I never told him. I wish I had. He changed the direction of my life and he didn't know it. He was just doing what he always did, which was paying attention to someone who needed it. That's who he was. That's who you took. He addressed Dylan directly at the end. I hope, someday, you understand what you destroyed. I genuinely hope you do. Not as punishment. Because understanding it might be the only thing that makes any of it mean anything. He folded his statement, walked back to his seat and sat down. The courtroom was quiet. Judge Patricia Harmon made a note on her legal pad, capped her pen and looked at Dylan Mercer. It was time for the sentence. Judge Patricia Harmon had been on the bench for 17 years. She had sentenced defendants to death. She had sentenced teenagers to rehabilitation programs and watched some of them rebuild their lives. She had presided over trials that had made her doubt the system and trials that had made her believe in it. She had, in that time, developed what colleagues described as an almost preternatural ability to separate emotion from reasoning, to feel the full weight of what happened in her courtroom and then deliver justice from a place that was clear and steady and exactly correct. On November 15, 2020, Judge Harmon reached for that steadiness and delivered the most widely discussed sentencing statement of her career. She began with a procedural note about the sentencing guidelines and the range available to the court under Ohio law. This lasted approximately 3 minutes and was dense with legal citation. It was, observers understood, a deliberate choice, beginning in procedure before moving to substance, establishing the legal framework before she addressed the human one. Then she set down her papers, removed her reading glasses and looked at Dylan Mercer. Mr. Mercer, she said, you are 16 years old today. You were 14 when you began planning this crime and 14 when you committed it. I am aware of your age. I have been aware of it throughout these proceedings. I am not going to minimize its significance to you or to this court. Age is a morally relevant fact. It is not, however, the only morally relevant fact. And in the specific circumstances of this case, it does not override the others. What this court has before it is not an impulsive act committed by a teenager under pressure. It is not a moment of rage or fear or desperation. It is something rarer and more troubling. A sustained, premeditated, methodically executed campaign to end the life of a person who loved you and trusted you and had done nothing, to justify what you did to him. She paused. The court has reviewed the evidence extensively. It has reviewed the psychological evaluation. It has considered the certification records, the trial record, and the victim impact statements presented today. The court has considered everything it is required to consider and many things it is not. The journal, she said, is the heart of this case. Not the toxicology, not the dark web transaction, the journal. Because the journal is your voice. And your voice, across 43 entries, records not a moment of madness but a process of deliberate choice. Entry after entry you describe what was happening to your father and you continue. You adjust the dose. You note the effects. You manage the timeline. And in entry 22 you write, and I am quoting directly from evidence, that your father trusts you completely, and that this makes it easier. Easier. You used your father's love as a tool. You used his trust as a mechanism. This court cannot read those words and attribute them to anything other than what they plainly are. The record of a deliberate choice, made by a person who understood what he was doing, made again and again across 43 days. This court is also aware, Judge Harmon continued, that sentencing a minor to a term that will extend well into his adult life is an act of immense gravity. It is not done lightly. It is not done without recognition of what it means for a human being who has not yet lived most of his life. The court does not take that lightly. But the court is also obligated to consider what Robert Mercer's life meant, what its ending cost, what the safety of the community requires, and what accountability, genuine, proportional, lasting accountability, demands of this moment. She picked up the sentencing order. It is the judgment of this court that Dylan Mercer be sentenced on the charge of murder in the first degree, to a term of 60 years, to be served without possibility of parole for a minimum of 50 years. On the charge of conspiracy to commit murder, 15 years to run consecutively. On the charge of criminal procurement of a controlled substance, 10 years to run consecutively. The total term of incarceration is 85 years. She set down the order. This sentence reflects the gravity of what was done, the planning that preceded it, the suffering it caused, and the court's judgment that the protection of the public requires a substantial period of incarceration. She looked at Dylan for a long moment. Mr. Mercer, I hope you use the time you are given to understand what you chose to do. I hope you come, eventually, to understand it fully. The court is adjourned. The gavel fell. The sound echoed off the courtroom walls. Dylan Mercer sat very still for a moment. Then he stood as required and was taken by 2 officers through the side door. He did not look at his mother. He did not look at his aunt. He looked straight ahead, jaw set, and walked out of the room. The door closed behind him. In the gallery, Carol Mercer sat with her eyes closed. Karen Mercer stared at the place where her son had been. The courtroom emptied slowly, as courtrooms do after the gravity of something real has made the air heavy, and people carry some of it out with them when they go. The sentence was appealed within 60 days. Webb filed on grounds that the adult certification had been improperly granted and that the sentence constituted cruel and unusual punishment in violation of the Eighth Amendment as applied to a juvenile defendant. The appeal cited Miller v. Alabama, the 2012 Supreme Court decision that prohibited mandatory life without parole sentences for juvenile offenders, and Montgomery v. Louisiana, which extended that protection retroactively. The Ohio Court of Appeals agreed to hear the case. It took 14 months. The appellate court issued its ruling in February 2022. It upheld the adult certification and upheld the sentence in full, with a 2-1 ruling. The majority opinion, written by Judge Annalise Hartmann, carefully distinguished the Mercer sentence from the life without parole framework addressed in Miller. Dylan's sentence, while long, included a parole eligibility point, at age 101 if all time was served, and thus did not technically constitute the mandatory LWOP that Miller prohibited. The majority further found that Judge Harmon had considered Dylan's age explicitly and at length, satisfying the individualized sentencing requirement established in Miller. The dissent argued that a sentence effectively guaranteeing a person would die in prison, imposed on a minor, required a higher standard of justification than the majority had applied. Webb petitioned the Ohio Supreme Court for review. The Ohio Supreme Court declined to hear the case in September 2022. The Eighth Circuit declined federal habeas review in 2023. The sentence stands. Dylan Mercer, convicted of first-degree murder at 15 and sentenced to 85 years, is currently incarcerated at a medium-security Ohio correctional facility. He will be eligible for his first parole review, under the terms of the sentence, in 2104, when he would be approximately 100 years old. He will not leave prison. The case had effects that extended well beyond the courtroom. In Ohio, legislators introduced a bill, informally called the Mercer Provision, requiring standardized toxicology screening for thallium in all unexplained adult deaths presenting with peripheral neuropathy or unexplained alopecia. The bill passed in modified form in 2021. Dr. Ibarra, the medical examiner whose clinical observation had flagged Robert's death before a standard panel would have caught it, testified before the state legislature's health committee and described the near miss. If Robert's case had gone through the standard protocol without Dr. Walsh's referral, the cause of death might have been listed as cardiac failure and the poisoning might never have been detected. The Westfield County School District, in partnership with the local mental health authority, implemented a new early intervention screening program for students exhibiting behavioral markers associated with callous unemotional traits, the psychological literature's term for the reduced empathy profile associated with Dillon's assessment. The program was designed not punitively but therapeutically, to identify young people who might benefit from early targeted mental health support before crisis. Whether the program would catch another Dillon Mercer was unknowable. Whether it might catch someone earlier before harm was done, was the hope that motivated it. Karen Mercer moved from Cincinnati to a small town in rural Kentucky in 2021. She gave one interview to a crime journalist, and said only that she thought about Robert every day, that she thought about Dillon every day, and that she had not yet found a framework for holding both thoughts at once. He is my son, she said. He is also someone I do not recognize. I do not know how to be the mother of someone I do not recognize. She asked not to be contacted again and has not spoken publicly since. Carol Mercer returned to nursing. She volunteers on weekends at a suicide prevention hotline. She keeps a photograph of Robert on her desk, not from his adult years but from when he was 12, holding a model rocket he built with their father in the backyard of the house they grew up in. She described the photograph in a social media post in 2022 that was widely shared. "This is my brother Robert. He loved physics, pancakes and his son. He was a good man. He deserved a long life. He didn't get one. But he was here and he was loved, and I will keep saying so for as long as I can." James Whitfield, Robert's former student, completed his PhD in physics in 2023. His doctoral dissertation, a study of momentum transfer in quantum systems, is dedicated to Robert Mercer. The dedication reads, "For the teacher who stayed. You changed everything." He teaches now, introductory physics at a community college in Pennsylvania. He describes teaching as the best thing he knows how to do with what Robert gave him. He says he tries to stay after class for the students who are struggling. He tries to pay attention. He tries to be the kind of teacher Robert was. He says it is harder than it looks. He says it is worth doing anyway. There is a photograph in the Westfield High School hallway, a faculty portrait from the 2018 to 2019 school year, the last year Robert Mercer taught there. He is in the second row, third from left, wearing a blue Oxford shirt and the slightly too wide smile of someone who was told by the photographer to look natural and isn't sure what natural looks like. He looks happy. Unremarkably, genuinely happy in the way people look when they are photographed in the middle of lives they are glad to be living. The school has not removed the photograph. Several students, over the years since his death, have placed small items beneath it in the hallway, a piece of chalk, a track ribbon, a handwritten note. Dillon Mercer does not appear in that hallway. He is not a ghost in that school. He is an absence, a specific bounded absence in the shape of a boy who was there and then wasn't, who left behind not a memory but a wound. The students who were at Westfield High during the trial years remember him only as someone who was gone. The younger students know the story. They have read about it. They do not know what to do with it in the way that people often don't know what to do with things that are incomprehensible, that sit outside the normal grammar of cause and effect and consequence. 85 years is a number that is difficult to hold in the mind in any meaningful way. It is longer than most people live. It is longer than Robert Mercer lived. It is longer than the gap between now and the end of the Second World War. It is the answer in this case to a question that the law asks but that no answer fully satisfies. What is the appropriate response to an act that cannot be undone? The law does what it can. It removes the person from the world that was harmed. It pronounces a duration. It closes the case file. It cannot restore Robert Mercer. It cannot give Carol her Sunday phone calls back. It cannot give Karen Mercer a framework for loving a son she does not recognize. It cannot give James Whitfield the chance to tell his teacher what those 3 afternoons meant. The law is not equipped to give any of those things. It gives what it has: a verdict, a sentence, a door that closes. Judge Harmon retired from the bench in 2023 after 30 years. In a retirement interview with the Ohio Bar Association's Journal, she was asked about memorable cases. She mentioned several. She mentioned Dillon Mercer last and briefly. "It was the case I thought about most afterward. Not because of any doubt about the verdict or the sentence. Because of the question it left that I couldn't answer, and that I don't think the law is designed to answer. How does a child become that? What happened or didn't happen that produced a person capable of that at 14? I don't know the answer. I don't think anyone does. That question stayed with me. The question has stayed with many people. It is perhaps the defining unanswered element of the Mercer case. Not what Dylan did, which is documented in excruciating detail, but why. The forensic record is comprehensive. The psychological evaluation is thorough. The evidence is overwhelming. None of it explains what happens inside a person that produces the ability to sit across from your father at breakfast and watch him eat the thing that is killing him and not stop. The closest anyone came to an answer was Dr. Greer in his evaluation, where he wrote that Dylan appeared to have no experienced connection between his actions and other people's suffering. That is a clinical description. It is accurate as far as it goes. It does not fully explain. Robert Mercer would have been 46 in 2024. He would have, in all likelihood, become department chair. He would have kept coaching track, kept running on the trail behind the elementary school, kept calling his sister on Sundays. He might have visited Dylan in prison. He was that kind of man, the kind who didn't stop loving the difficult thing. He might have been one of the parents who drove to Ohio State for engineering open houses. He might have sat in a stadium somewhere and watched his son receive a degree, the way he had planned in the summer of 2019 before everything ended. He might have made more pancakes. He would have kept paying attention. He was that kind of man. The smirk in the courthouse hallway lasted 4 seconds. It was captured by a camera that Dylan did not notice. It was played for a jury that remembered it. It was described in a sentencing statement by a judge who had seen 30 years of defendants stand before her and had not seen one who looked like that. The smirk said, "I did this and nothing will happen to me." The 85 years that followed said, "You were wrong." Justice does not always come quickly. It does not always come cleanly. But in the long arc of a case built on evidence and argued with precision and decided by 12 people who took their responsibility seriously, it came. The gavel fell. The smirk was gone. And Robert Mercer, for the first time since he sat down to those pancakes on the last Sunday of his life, was something the law could give him. Witnessed, honored, and not forgotten. If you believe in accountability, and in the idea that truth, no matter how carefully it is hidden, has a way of finding its way to the light, share this story with someone who needs to hear it. Justice is not automatic. It is built, piece by piece, by the people who refuse to look away. Robert Mercer deserved that. He got it. Remember his name.